Thank you for joining us for today's webinar on workers' compensation and COVID-19. I'm Adam Rossi from the Communication Outreach Unit here at the Workers' Compensation Board. And today we will discuss the basics of the workers' compensation system, as well as information to help workers who believe they contracted COVID-19 on the job, especially those who have missed time from work or are suffering from ongoing or long-haul symptoms. We do ask that you please keep your phone lines muted, as we will be using the chat feature to receive your questions today. You can enter your questions throughout the presentation in the chat box located on the right side of your screen, and we will answer as many of your questions as we can. But if you have questions that we don't get to today, or if you think of something after the session ends, we will be providing you with resources at the end of the presentation. Also, just want to mention you can enter your questions throughout the presentation, but we will hold off until the end to answer them. Joining today to assist with answering your questions, we have the board's Medical Director, Dr. James Tachi, Acting General Counsel Heather McMaster, and our Advocate for Injured Workers, Joe Cavalcante, who is going to say a few words to kick things off.
Thank you, Adam, and thank you everyone for joining us. The Office of the Advocate for Injured Workers here at the board exists to support the injured workers of New York State. We are here for you. In today's presentation, we'll share important information about workers' compensation for employees who have contracted or who do contract COVID-19 due to an exposure in their workplace. As part of this, we'll be detailing how and when to file a claim. And the when here is really important, and one of the key reasons why we're doing this webinar today. Workers have 2 years from the time they contracted COVID-19 to file a claim. So if you believe you contracted COVID-19 in the workplace in the autumn of 2020, you need to file a claim now. You'll also learn what to include in your claim to show you had COVID, and also that your COVID-19 was work-related. I look forward to answering your questions at the end, so let's get started. I'll now turn this back over to Adam. Good afternoon, Adam.
Thank you, Joe. Good afternoon. All right, let's take a look at today's agenda. We will start by explaining what workers' compensation is and what your rights are if you become injured or ill on the job. Then we will discuss how workers' compensation can help those affected by work-related COVID-19, including workers who are facing ongoing or long-haul symptoms. We'll talk about the importance of filing a workers' compensation claim and walk you through the process of doing so, including the medical documentation that's needed to support your COVID-19 claim. Finally, we'll point you to some helpful resources for more information or assistance with filing, and we will leave time at the end to take any questions. So let's start with a brief overview of workers' compensation. Workers' compensation is a no-fault insurance system and is usually covered by insurance through an employer, unless the employer is self-insured. We'll discuss this more a little later in the presentation. An employer cannot charge a worker for the cost of this insurance, and it provides medical care and lost wage benefits to workers who are injured or become ill on the job. An employee is considered anyone providing services to a for-profit business or any compensated individual providing services to a nonprofit organization, regardless of employer size. The only exceptions are clergy and some school teachers, although the vast majority of school teachers in New York State are voluntarily covered. There is no cost to the worker to receive the necessary medical treatment for a work-related injury or illness. This is a lifetime benefit unless the worker signs a settlement or a Section 32 agreement that closes any medical eligibility for a payment. This includes all medical expenses such as tests, hospital visits, medications, physical therapy, equipment, and home care attendance. Transportation costs for travel to all medical appointments or treatments are also reimbursable for life, and there is no time limit to when a worker can file to have these costs reimbursed. Now let's discuss the workers' cash benefit, otherwise known as the indemnity benefit. 2/3 of a worker's average weekly wage is payable while the worker is out on workers' compensation with 100% disability. This includes all compensation, so for example, tips, perks, etc. The maximum benefit is now $1,125.46 per week. This is based on New York State's average payroll and is recalculated every July 1st. Benefits in the workers' compensation system are temporary, except in the event of a permanent injury. In that case, the worker will be evaluated to determine whether they have a permanent total disability or permanent partial disability. Finally, there are payments for a loss of a use of a limb. This is known as a scheduled loss of use award and may be eligible for injuries to the following: your arm, hand, fingers, leg, foot, toes, eyesight, hearing, or disfigurement. There is also a fatality benefit, which is payable in instances where a worker perishes due to an incident, consequent of a previous incident, or an illness, such as COVID-19, while at work. With this benefit, funeral and memorial expenses are reimbursable up to $12,500 in the New York metro area and $10,500 throughout the rest of New York. Surviving family members are also entitled to weekly benefits, which are calculated the same way as the indemnity benefit, which is 2/3 of the deceased worker's average weekly wage. Beneficiaries include the spouse of the worker, children up to the age of 18 or 23, and any disabled or blind dependents. If none of these parties exist, $50,000 is payable to the parents of the deceased worker. If there are no surviving family members, $50,000 will be paid to the estate. In terms of who pays workers' compensation claims, that depends. If your employer purchased an insurance policy, the insurance carrier who wrote the policy pays the benefits. If your employer is self-insured for workers' compensation, your employer pays the claim. Usually, self-insured employers use a claim administrator to handle the claims, so you'll be interacting with that claim administrator in that situation. That's known as a third-party administrator. When the employer does not have the required workers' compensation insurance coverage in place, the Workers' Compensation Board will pay claims so the workers can get their needed benefits, and then the board recoups the cost from the employer, along with any penalties for not having the insurance in the first place. Workers' compensation is a worker's legal right. If you are injured or become sick at work, you are entitled to workers' compensation. It cannot be negotiated or signed away. Also, immigration status is not a factor. The board offers free language assistance if you would like it. So what is the role of the Workers' Compensation Board? The board administers and oversees the workers' compensation system. However, as previously mentioned, we do not typically pay the claims unless the employer has failed to provide proper worker compensation coverage. We have approximately 1,000 employees across 24 offices and hearing points statewide. Our role is to ensure the system operates correctly by receiving reports of all injuries, payments, medical reports, and any other documents relevant to the claim. We will also hold hearings in front of an administrative law judge when appropriate to adjudicate or move a claim forward. So hopefully that gives you a high-level understanding of the workers' compensation system, your rights and benefits if you become injured or ill on the job, and the role of the Workers' Compensation Board. Now let's discuss what you need to know and what actions you should take if you contract COVID-19 at the workplace. The very first thing to do when you are sick or injured on the job is to seek treatment. In an emergency, you can see any healthcare provider, but otherwise, go to a provider who is authorized to treat injured workers by the Workers' Compensation Board. You can find one using the provider search on our website, at wcb.ny.gov. You can also visit your local New York State occupational health clinic for treatment from an authorized provider. You can search for your closest clinic on the Department of Health website, and that link is there on your screen. Tell the provider who treats you that you believe you contracted COVID-19 from an exposure at work. Share any details about your workplace to back that up. For example, how would you describe your workplace? Was there public contact? Were masks worn? Did any of your coworkers have COVID-19? As well as any other circumstances the provider should know about your potential exposure. If your healthcare provider agrees, they will send a medical report to the insurer and to the board. It is best that the medical report includes your positive COVID-19 test result, but a medical report showing a diagnosis via a PCR test or by virtue of an examination may also be used. You will need to notify your employer in writing that you believe you contracted COVID-19 at work. An email or a document is best. A text message can be accepted, but it is not recommended because sometimes they're not easy to find and duplicate if necessary. Notify your employer as soon as you can, but no later than 30 days of becoming ill. Your employer is then required to notify its workers' compensation insurance carrier. Now let's take a look at how to file a COVID-19 workers' compensation claim. You should file a workers' compensation claim, number one. Workers are not required to file a claim because the insurance payer must notify the board of the incident. However, filing your own claim is a valuable protection and is extremely helpful, as I'll explain in a few minutes. As Joe mentioned earlier, you have 2 years from the time you contracted COVID-19 to file your claim. So if you are approaching this deadline, you need to file your claim as soon as possible. The fastest way to file the employee claim form, the Form C3, is online. You can visit the COVID-19 area of our website, and you'll see that link there on your screen. And you can also file a paper form, which you can download from our website. Follow the instructions on the form for submitting it to the board. We would like to note that the C3 form you fill out is the same form used for any injury or illness experienced on the job. It is not specific to COVID-19. If you have questions while you're filling out the form, please do not hesitate to contact us. If you have a PCR test result showing you had COVID-19, file that report. That's very important to your claim. If you had COVID-19 early in the pandemic and you got your results by phone, as many people did, you should now get that result in writing and file that. So what do you need to share in your claim to show your COVID-19 illness is work-related? Most workers cannot point to the exact moment or method of exposure to COVID-19. However, you can demonstrate a high risk in your workplace if you work in an environment where exposure to COVID-19 is or was prevalent. For example, a hospital, transportation job, a grocery store, or anywhere else. On the claim form, include details about where you work, how often you work, and your job duties, especially those involving public contact. Section D of the claim form has space for you to share any relevant details. While not all claims will be accepted, there is no harm or risk in filing a claim, even if it ends up getting denied. Filing a claim is important for anyone who believes they contracted COVID-19 at their job, and especially those who are missing work or experiencing ongoing symptoms, as there may be benefits that can help you right away. If you are experiencing long-haul medical issues due to work-related COVID-19, you may be eligible for free lifetime medical care. If you miss more than 7 days of work due to work-related COVID-19, you may be eligible to receive lost wage benefits. This may be very helpful to long-haul sufferers who regularly miss time from work due to medical appointments or worsening symptoms. For anyone who contracted COVID-19 on the job, whether or not you had access to and used paid sick time, and whether or not you've recovered, it is important to have an established claim, a record that your COVID-19 was work-related, should you suffer long-haul complications and need workers' compensation benefits down the line. If you already have an established claim for COVID-19, any lost wage benefits or ongoing medical care that is directly or consequently related to COVID-19 falls under that existing claim. For example, someone with an established COVID-19 claim may also need ongoing treatment for problems for COVID-19 related to their kidneys or lungs, or they may develop consequential conditions such as anxiety or depression. If you need help filing a claim, you can call our toll-free customer support line at 877-632-4996. Free language assistance is also available. If you face resistance or obstacles to getting information about the claims process, or if you're discouraged from filing a claim, please let us know. We will help you. Email our Advocate for Injured Workers at advocateforinjuredworkers@wcb.ny.gov. So what happens once you file? If the insurer accepts or agrees with the claim, it will be payable, and this is known as compensable. If the insurer disputes the claim, a judge at the board will decide whether the claim should be paid. Right now, everyone has to attend our hearings remotely because our offices are closed to the public. While the attorneys must attend by video, injured workers have the choice to either participate by telephone or by video through the virtual hearing center. Your hearing notice will contain all the details. The judge may hear testimony to get the facts about where you work, whether you were exposed to COVID-19, the extent of exposure, and whether exposure to COVID-19 was prevalent in your work environment. Remember, you do not need to pinpoint a moment in time when you think you were exposed. We review all the facts in a claim. From there, it is possible to appeal a judge's decision, and we have an appeal process if that happens. Now we'll take a look at the additional resources that are available to you. For more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and filing a claim, please visit wcb.ny.gov/COVID-19. On that page, you'll also find numerous resources such as fact sheets, frequently asked questions, and more. You can also subscribe for email updates related to COVID-19 and workers' compensation by selecting the Subscribe for Updates button on the top of the page. For other helpful information for workers on workers' compensation and other topics, you can visit the Workers page of the board's website at wcb.ny.gov. Finally, our Advocate for Injured Workers is also at the ready to help injured workers who are having difficulties with their claims or trouble accessing their benefits. You can contact the Advocate's office by calling 877-632-4996 or emailing advocateforinjuredworkers@wcb.ny.gov. We also have a very active social media presence to help you stay informed on workers' compensation topics and for the latest news from the board. Follow us on our social channels to learn about future webinars like this one, as well as information and webinars on New York State paid family leave and more. Our Twitter, Facebook, Instagram, and YouTube handles are on the screen. I do want to point out that YouTube links here real quick. I see a question in here. Do we have a copy of the slide? If you go to our YouTube page, you can see a previously recorded version of this presentation. And on that note, yes, we do have a copy of this presentation on our website as well. If you go to the COVID-19 page, you'll see it there. So thank you for attending this presentation on COVID-19 and workers' compensation. We do hope that you found this information helpful, and we will now take the rest of your time to answer any questions you may have. Again, please enter your questions in the chat box on the right side of your screen. Our subject matter experts will take a look at them, and we will be back with you shortly with some answers. Thank you.
Hi, this is Dr. Tachi, and there's a question that reads, how can you prove you got COVID at your workplace? That seems to be a slippery slope to me. So that question actually came in, I think, a little bit before it was covered in one of the slides. And I would just say that, proving a causal relationship between an injury and an illness and your job can be complicated, whether it's COVID or not, right? So to do, if you think that your COVID was related to work, is let your personal physician know that, your primary care provider know that. The gold standard, as was mentioned before, was the laboratory testing, not the home testing, because those are linked to you and your identity and their date and time stamped, et cetera. So they're the gold standard to use for the diagnosis. And then you explain to your provider where you work, what type of job you do, what type of activities, who may have been sick with COVID, et cetera, in your workplace at the time that you got sick. And, they'll take all that information, they'll put it together, and they'll help you to arrive at a decision as to whether or not you think it's work related, and they will package that up and submit it as part of your claim.
Hi, this is Heather McMaster. There's a question here about whether an employer should be paying COVID sick pay to an employee who did not contract COVID at work. So COVID sick pay is something completely different, and that is actually administered by another agency, the Department of Labor, but it is a benefit available whether or not the contracture of COVID occurred at work or someplace else, or they're uncertain.
We have another question here from a worker who's being paid on a 1099 rather than a W-2, I suppose. And the worker is asking, can I still receive workers' compensation? The answer is, it is certainly within the realm of possibility that you would be considered an employee for workers' compensation purposes. So yes, we realize that you're on a 1099. You might be considered independent contractor for tax purposes, hence the 1099. But our system here has its own laws, its own rules and regulations, and ultimately the Workers' Comp Board, our agency, would make a decision regarding whether you were an independent contractor or an employee for our purposes. So the bottom line is you can file that claim, just be truthful, file the claim, and if there's a dispute, the board will resolve it.
There's a question, if my positive PCR test was taken in another state, but I believe that the COVID was contracted at work, am I still eligible for long COVID benefits? It gives the date being back in March of 2021. So irrespective of where the testing is done, if your COVID was contracted in the course of your employment in New York State or with a New York State employer, et cetera, and the location of where you may have contracted it, depending on whether you were working on behalf of your company, et cetera. It wasn't clear from the question if the individual was traveling or if they were just traveling when they got the symptoms and they had been in New York State at the time that they contracted the COVID. But long and short of it is, if the COVID itself is deemed related to your job, then where the testing was performed is not relevant. The PCR testing is the same if it's done in another state versus if it's done here.
All right, we have a few more questions here. What responsibility does the employer have to notify employees of the option to submit to workers' compensation? Well, the employer certainly has an obligation to hang a poster in a prominent area that indicates the employer is carrying insurance, the workers' comp insurance, and who the carrier is. The employer also has the obligation, if told by a worker that there was a work-related incident, the employer is obligated to tell its insurance company or its insurance payer, who then tells us, and then a claim gets kicked off, or begun, I should say. From there, it would be a very enlightened employer who would mention workers' compensation possibilities to its employees as well. We have another inquiry here. I'm going to read it to you. Suppose the worker told the employer immediately of COVID, that the worker had COVID, and the worker does this verbally and says, I strongly suspect I got infected at work. And then the worker got leave for the acute illness. The worker didn't put it in writing, and nobody at the employer said anything about filing a claim. What should I do? Okay, so here's what you should do. You gave your employer verbal notice that you thought you got it at work. Okay, very good. If you want to follow up with the written notice, go ahead and do that. Hopefully, your employer told its insurance company, and its insurance company hopefully filed a notice with us. If not, well, you may certainly file a claim, and that will get your whole process initiated and begun. Regarding the rest of it, yes, you certainly should be seeking medical care as appropriate. If you have a PCR test, you're going to need to file that to demonstrate the fact that, number one, you did have COVID. And as we also indicated, while Dr. Tachi is explaining how the PCR test is what we call the gold standard, if you don't have a PCR test, well, you should see your healthcare provider, and your healthcare provider will file a report, and your healthcare provider will give an opinion regarding the likelihood that you, A, had COVID, and B, may have contracted it on the job. So the bottom line here is you might need to go ahead and file the claim. We always recommend you can file a claim. It's called a C3 yourself. Get that PCR test. Get any medical records sent in to the board to support your claim.
There's another question. What constitutes evidence of workplace prevalence of COVID? And just to be clear, and just like Joe clarified that, it's ideal to have a PCR test, but you don't necessarily have to have one to file the claim. You can file it, and you and your provider can sort of make the case and see how it goes. You don't have to prove that there's workplace prevalence of COVID to show that, meaning there's a lot of people in the workplace at the time that you're working that have COVID. You can contract COVID from just one person, right? If you have very close and prolonged contact to them. So what you're trying to demonstrate is not that there's a widespread prevalence of COVID necessarily in your workplace, although evidence of that is certainly helpful in determining causal relationship. You're not required to. You just have to connect the dots, you and your provider, as you talk about it, as to why you think you may reasonably have contracted COVID at the workplace. And like I said, there could be a workplace of 100 or 1,000 people, but it may just be very close proximity, close and prolonged proximity to one of those people who was COVID positive that may have been the cause of your case. So you don't have to prove prevalence. There's a question about basically someone's case of COVID seemed very mild at the time. They didn't worry about it. At the same time, they lost the particular job they were in. And they also, as this was happening over the course of a month's time or so, they developed long COVID. And the long COVID symptoms are bad enough for them to worry about what they had previously considered a mild case. And I would say that, first of all, we're still learning about long COVID, and it can be complicated, and it can involve several different types of symptoms and body systems, et cetera. But going back to what we said earlier, if you think your COVID case was related to work, you and your healthcare provider should file that claim. And if you think you have long COVID related to that COVID claim, then you should similarly, you and your healthcare provider would document the presence of long COVID and he or she, in terms of referrals or additional diagnostic testing or additional treatment, et cetera, for the long COVID, should be putting that in as part of your COVID claim. So even if the initial symptoms were mild, but now the long COVID symptoms are problematic, they all still relate back to the initial claim, and that's how you should handle it.
Yeah, we have a question here about whether COVID is considered an accident or an occupational disease under the workers' compensation law. Those are the two ways that a workplace injury or illness can be characterized, and the answer is that it's almost always an accident.
We also are receiving a number of comments, and thank you for being engaged and giving us your thoughts and your comments. But I feel like we ought to reply to the number of comments we are receiving from people who are explaining, briefly they are, thank you again, these little situations that occurred in their workplaces where maybe there were 4 people who had COVID and now they're the 5th person to have COVID in the workplace, or somebody came to work because he or she didn't have health insurance and they had an active case of COVID. And, you know, we're getting all these little scenarios. We're getting more questions about giving the employer notice. I think that I can really answer all these questions very briefly by simply reminding us of what we're doing here. What we're doing here is we're saying, ladies and gentlemen, if you believe you got COVID in the workplace, okay, so all those little situations, if you believe you got COVID in the workplace, tell your employer, file a claim, okay? All these other things, they're peripheral. They're not really where you need to be for workers' comp purposes. But those details of all these little instances, like, for example, the person who worked with 4 people who also contracted COVID, well, that is a detail that you would probably want to include on your claim, or you would probably want to share with your healthcare provider. Because now, if you do know of 4 people who had COVID in the workplace at the same time, well, we might be talking about prevalence, and you might be demonstrating that there is a likelihood that you contracted COVID in the workplace. So let's really remember these basic things. If you think you got it in the workplace, get a test. You have a test. Doesn't matter what state the test was taken in. Just, as Dr. Tachi was saying, you have a test, you have a PCR test, file it, and file the claim. Here's a question that, to the question writer, this is a rather common question, okay? So don't feel funny about posing this question. Would filing a claim negatively affect my employer? Well, your employer, by law, ought to be carrying workers' comp insurance. Or if your employer is self-insured, like, say, a city or a county, provisions have already been made to pay the claim. Okay, that's the whole purpose of this insurance. So the employer doesn't have to handle the claim itself. There's an insurance policy. Maybe there's a claim administrator to handle things. And so to that extent, no, it's not going to negatively affect your employer. The most important thing to remember is this is about you as a worker. You really should be protecting your health. Remember we said earlier that medical care is a lifetime benefit? Well, in workers' compensation, that pertains to whatever the nature of the injury or illness is. So that would pertain to COVID. So that would also pertain to the questions that always come into us about what's known as long-term COVID, long haulers, people who deal with COVID for months or years after the initial infection. Well, if you have an established workers' comp claim for COVID, treatment or anything related to that is going to be a benefit available to you for the rest of your life. We have a question from one of our neighbors in the great state of the Commonwealth of Pennsylvania, as they say. Our questioner says that the questioner is a resident of Pennsylvania and is trying to get some insights. And the question boils down to, what do we do here in New York if the employer is not carrying workers' comp insurance? Well, we touched on that at a very surface level earlier, but for a little more detail, yes, employers are almost always required to carry workers' comp insurance. In this state, there are some pretty limited exceptions. So let's say we have an instance where a business should have had workers' comp insurance. Well, everything that we said still prevails. The worker should still be filing a claim because in this case, the employer doesn't have insurance, so there's no insurance carrier to start the process. Okay, so now the burden's pretty much on the worker. So the worker should file the claim, the C3, and the worker should tell the healthcare providers that this is a work-related incident, because now those providers, instead of sending the reports and bills to the insurance company and to the board, well, there's no insurance company, so they'll just send it to the board. However, we have a process in place here in New York State to ensure that the claim does get paid even though there's no insurance company. We have a special fund set up here at the board. The name of it is the Uninsured Employers Fund, as a matter of fact. And the Uninsured Employers Fund will actually take the claim in, review, adjudicate, make the payments as necessary and required so the worker gets the care, gets the lost wages, and then the last element is we will now bill the scofflaw employer. We will now probably implement some penalties on that employer as well. But the whole process should keep the worker covered, getting the benefits necessary, and, as they say, held harmless. The question is asking about the loss of the sense of taste and the loss of the sense of smell that can accompany COVID illnesses. And the questioner is asking if there's a special benefit for that. There is not a special benefit in place to reimburse or to account for the loss of taste and smell. However, if I were you, I certainly would include that in any discussions or exams I have with my healthcare providers, and I certainly would bring that forward, but there's no special type of compensation for those disabilities or maladies at this point.
Thank you, Joe. That seems to be all the questions we have. We'll stay on the line for a couple more minutes. In case you think of something, feel free to enter in the chat. But I just want to remind you that we do have a copy of this slide deck as well as a recorded version on our website. If you go to wcb.ny.gov/COVID-19, there's a section that you'll see, I think it says webinars and more information. Just click on that and you can find the slide deck and the recorded presentation link. And again, you can just go to our YouTube page. It is youtube.com/NYSWCB, and you can find this presentation as well as dozens upon dozens of other workers' compensation recorded webinars on there as well.
There's a question that someone stated that they did get a positive PCR test back in January, presumably when they were initially diagnosed with COVID, and it was at a quote pop-up clinic, and they're having trouble looking it up, and they're wondering if if there's a centralized system to look up the results. The best way to do that would be to contact whomever was hosting the pop-up clinic. Most of those were done by county health departments. Some were done by hospitals and health systems. And they would be the best source, particularly if you can give them the approximate date of your testing and of course your name, et cetera. They can give you the best source for tracking down your PCR test results. And again, most of the pop-up clinics were conducted by the county health departments. Some were done by hospitals.
All right, thank you, Dr. Tachi, and that appears to be all the questions we have. So I want to thank you all for joining us today. I want to thank Dr. Tachi, Heather, and Joe for joining us to answer your questions. Some great questions that did come in. We always appreciate your participation in this. Just a reminder that more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and for filing a claim, can be found at wcb.ny.gov/COVID-19. You can also subscribe for email updates related to COVID-19 and workers' compensation by selecting the Subscribe for Updates button on the top of the page. To receive other workers' compensation news, including information on future webinars, visit wcb.ny.gov. Scroll down to the bottom of the homepage and you can select Get WCB Notifications. For other helpful information for workers, you can visit the Workers page on the board's website at wcb.ny.gov. Again, a recorded version of this presentation and a copy of the slide deck are available on our website. Go to wcb.ny.gov/COVID-19. You go to the middle of the page, there's a section there that will say more information and webinars, something along those lines. I can't remember the exact wording of it. But you just click on that and you'll find a copy of this slide deck as well as a link to our YouTube recorded presentation. And again, speaking of YouTube, we do encourage you to follow us on social media. Please be sure to follow us on Facebook, Twitter, and Instagram, as well as YouTube. Again, thank you all for joining us. Please continue to stay safe and enjoy the rest of your afternoon.